Hi, everyone. This is a quick recap of the presentation we provided during today's webinar about President Biden's new executive order on promoting competition in the American economy, which was announced last week. The executive order addresses 72 initiatives and is the result of Biden's campaign promise to increase competition in the economy. The administration cites in its prelude the corporate consolidations in the past few years that have resulted in increased prices for consumer products, lower wages, and a lack of innovation and economic growth. We're not going to touch on all 72 initiatives during this brief recap. We're going to talk about the initiative relating to non-competition agreements and licensing requirements. The executive order created the White House Competition Council, which is tasked with implementing the initiatives and advancing the initiatives in the executive order. That is comprised of the chair of the National Economic Council and cabinet members and heads of various federal agencies. Non-competition agreements are prevalent in our economy. They are provisions in an employment agreement that prohibits an employee from working for a competitor or starting a competitive business after they've left their employment with their prior employer. They often contain limitations on time and geographic limitations as to when they are effective. Sometimes employees don't realize they've signed them or have forgotten about signing them by the time they leave their employment. Biden's executive order encourages the limit or ban of non-compete agreements and encourages conformity in licensing requirements across the 50 states. Biden has tasked the FTC with working on imposing rules and regulations concerning non-compete agreements on a federal level. Traditionally, these agreements have been governed at the state level. They're generally disfavored by courts. They are generally disfavored by state attorney general's offices, which we've seen go after such agreement, particularly for low-wage workers in the past few years. We don't exactly know what's going to come out from the FTC, and there's no particular time frame within which non-competition agreements have to be addressed under this executive order. We expect that the FTC will not entirely ban non-competition agreements because there are times within which an employer needs to protect its trade secrets or confidential and proprietary information. We do expect that the FTC will come out with a rule that limits non-competition agreements, particularly those that are addressed to low-wage employees, but still allows employers to protect their legitimate business interests. So while we wait for that regulation or rules to be implemented by the FTC, we encourage you to have any non-competition agreements that you use in your business reviewed by your favorite bond attorney. They are disfavored, they are often restricted by the courts, and we can provide you some guidance as to the strength of your non-competition agreements and changes you may want to make to them in order to withstand a challenge in court. So until next time, thanks for listening.